State of Michigan versus Brandon Walters, docket numbers 18-463FH and 20-314FH. And this is the time set for a pretrial conference on both these files, and then also there is a bond motion on both the files. And Mr. Awuda-Coker is here for the people from the Attorney General's office, and Mr. Marks for the defendant. Mr. Walters is joining us via Polycom from the jail. And first of all, with respect to the pretrial, did you two fill out a pretrial statement or talk at all or anything? I don't have one.
No, Your Honor, we haven't, but I will assure you that Mr. Coker and I will get that into you no later than today.
Okay. Then I guess that takes us to the motion. Mr. Marks?
Thank you, Your Honor. What the court has before it is a motion to modify bond. As stated in the bond, currently my client is looking at a 10% bond on the 18463 docket and a 10% bond on docket 20314. Quite naturally, those are very minimum as far as bonds. However, my client is not in the position at this time to even come up with the necessary money, be it himself or through relatives, to even go to a bondsman, and more than likely it would be less than the $1,500 that would be required. What I'm asking of the court, and I understand as far as the current charge, my client understands the current charge and how that is not helping as far as in this type of request. However, I would argue that if the overall goal is to have my client start making payments, that can't be done if he's sitting as far as at the Ingham County Jail. He's been at the jail since March the 20th, and that's not even including as far as I don't know how long it took to bring him from Nevada as far as back to Michigan. So those days would be added on. I would simply ask the court to consider as far as a personal recognizance bond, looking at the recommendation by the pretrial service investigator. The information that he gave her is basically the same information that he gave me. He advised me that he was working as far as while he was in Nevada, in Las Vegas there, that basically he uses the internet as far as for this job. He advised me that he can do that from almost anywhere. He advised that the startup to get back into the swing of things would take 30 to 60 days. The income that he gave as far as the pretrial service of $700 to $800 a week to be able to make is the same information that he gave me. So I'm simply asking the court to consider as far as reducing or modifying the bond to that of personal recognizance. If the court wishes to question my client more about the employment factor, he can do that. Just another note as far as to inform the court as far as how my client is taking the matter seriously at this point in time. He has already signed the necessary paperwork in reference to his younger daughter as far as to start making payments in reference to her case as well. So he's aware of the financial responsibility he is under, and he just wants to get started, Your Honor.
All right, thank you. Mr. Awuda-Coker, I did see just this morning that the Attorney General filed a response, so I now have that, but anything you wanted to say?
Your Honor, I'd just like to note that Mr. Walters was given a PR bond in his 18463 case, and as a result of that, he failed to show up at a later court hearing in that file and the resulting absconding charge occurred. So people's position that the bond, as set in both files, both the 314 and 463 files, are more than appropriate, given the underlying factors in this case. And to be given another PR bond, there's no assurance that Mr. Walters would appear at future dates. I think that having some requiring the defendant to post some amount is needed for his future appearance at future court dates. And again, I think the bond set in both files is more than appropriate. So the people respectfully ask that the bond not be amended and remain as is.
Okay, thank you. Well, I previously tried to set the bond on the failing to pay child support case in a very low amount the last time I considered the bond, because I didn't think that Mr. Walters should sit in jail for a prolonged period of time on this predisposition. So he was unable to make that apparently, and then the new charge came up. And I understand with the new charge being absconding why the Attorney General has the position that they have, but I still think that I can fashion a bond that will ensure the defendant's appearance in court and have all appropriate safeguards in place, while at the same time getting him out of the jail, which he's been in for, I think, 122 days, which is probably way too long. So the recommendation, I think, is completely appropriate, and I will give a $5,000 personal recognizance bond on each file with the following conditions. Mr. Walters must report to pretrial services and must contact them immediately upon release. He may not travel out of state. He may not possess any firearms or dangerous weapons. He must reside with his mother at 1401 West St. Joseph Street in Lansing, and he must have a GPS tether attached prior to his release. Mr. Walters, I don't want you to talk, I want you to listen, okay? You may not leave the state of Michigan under any circumstances. You will have a GPS tether on your ankle, so we'll know where you're at all times. You have to reside with your mother on West St. Joseph Street. And you must report regularly to pretrial services. So they're going to give you instructions when they put the tether on your ankle, but whatever their instructions are, you have to make regular reports. If you don't live up to any one of those conditions, I will sign a warrant for your arrest and you'll end up picked up back in the jail. So can we reach an understanding on all of that?
Yes, Your Honor. A question about the tether. Will I be released to get the tether, or will I have to figure out a way to get the tether while I'm still incarcerated?
They'll take care of it. Someone's gonna come see you and place the tether, and once they do that, you'll be released.
Will I be in here 30 days? Will I be in here 30 days until that is?
No, it shouldn't take 30 days. It should take a day or two.
Okay.
If I may, Your Honor, as far as just to add on to that, please. I've had discussions with JSG about this, and basically they simply wait until a family member, the jail does not contact JSG if there's a change or a modification to where a tether needs to be added.
Seriously, I did not know that.
Yes, and it's confusing because I was surprised to hear that JSG simply waits until they're contacted by someone to go over to the jail.
Well, how about if I do an order and sign it and send it to JSG? Is that good enough for them?
I would. It works for me, Your Honor.
I will do that.
Okay, I appreciate that.
Sure. You're all set, Mr.
Thank you, then, Mrs. Draganchuk.
All right.
Hey, just follow the rules, that's all. Follow the rules, or you'll be right back in jail.
Yes, Your Honor.
So you're not going back to Las Vegas, that's out of the question.
Yes, indeed. I already filled that paperwork with Pathways you guys have in the jail, that, and they approved the application for me to receive housing funding. So
Very
I'll
good.
be setting up right here in the States, Your Honor.
Okay, but right now, your condition of bond is that you have to live with your mother. So if that's gonna change, then you gotta tell the people from the tether place and anyone else you're reporting to that you wanna change your address. But right now, you have to live with your mother.
Yes, Ms.
Okay,
Draganchuk.
I think we've reached an understanding on that. You're all set then, Mr. Walters. You can tell them at the jail you're done.